Hi, I'm Shaliz Sadig Romano, and I'm the co-managing partner here at Romano Law. Many people don't know that offer letters can be reviewed and negotiated before signing. The first thing to look out for are the basics. For example, the compensation structure, the title, benefits, location. Will this be in person or remote? Is that something that's important to you? It's really important to make sure that all of the agreed terms that you understand are also in the agreement as well. Secondly, is this an at-will or is this an employment agreement that requires a term or a commitment? For example, if things don't work out, can you easily resign, or are you required to stay for a certain period of time? There are certain industries where you might be signing something that has a term, and it's important to understand what happens if things don't work out. Finally, some big things to look out for and are really great areas for pushback or negotiation are restrictions on you and your career. You might see them referred to as restrictive covenants or protective covenants. These include the definition of what is deemed confidential. That's important to understand. This definition is often very broad and sometimes too broad, so there is an opportunity to push back and narrow the scope of what that definition is, of what you can reveal once you find out about it. What can you do after employment? What are your restrictions on you? Can you compete? And what happens if you create something outside the scope of your work, but while you're employed? For example, creative content, or you come up with an invention. It's crucial to understand if the company can own that and have rights to something that you created while employed. And this is a section in most contracts that can be reviewed and further defined to help protect the employee.